Hi, this is Michael Feigen. I'm a patent and trademark attorney, as you probably realized that already. This is my third presentation for Lawline, and I primarily obtain patents, trademarks, copyrights for people, and intellectual property in general. But today we're going to talk about patents, and more specifically, how to deal with the U.S. Patent Office. You can find me online, as well as my other videos on my website, patentlawny.com. Again, patentlawny.com. I'm available for consultations in Manhattan, and my main office is in northern New Jersey, just about 12 miles west of the Lincoln Tunnel, and also a satellite office in Philadelphia. So today's presentation, there's going to be an introduction, which I've kind of started already. Talk a little bit about how you draft the patent application. We talk about rejections based on not prior art, meaning, well, I'm going to call them not prior art rejections, but basically prior art is referring to previous patents, other things that are out there, and it could be any other disclosure anywhere in the world that is out there before your filing date. And that was prior art rejections. It's rejected because it's not new or obvious. That's going to be primarily what we're talking about today. And the non-prior art rejections are for things which are abstract, things which don't meet the statutory basis for patentability. We wouldn't be talking about that, say, even 10 years ago, more like 20 years ago before that, because abstract concepts people didn't try and patent so often. Let's go back a little bit of history, rather than just go right into the presentation. A little bit of history. There's one US president that has a patent. And seeing as my live audience is kind of quiet today, meaning there is none, we'll just have to make this as fun as possible. It won't be as interactive, but feel free. Ask me questions during the presentation. If you have comments on my trivia or the more substantive parts of it, that's fine too. But there was one president that actually has a patent, and that would be Abraham Lincoln. And back in his day, you actually had to provide models of patents. And many of those models, today it's no longer an issue, but many of those models have been destroyed. There was a huge fire at the U.S. Patent Office in 1836, destroying all of before that. But the patent system actually dates all the way back to 1790. George Washington was the first one to sign into law the patent system, and the first patent examiner was actually Thomas Jefferson, and rounding it out would be Abraham Lincoln, which was the only president with an actual patent to his name. And it seems that Theodore Roosevelt is the exception to the rule, because he is the only one that I can't find a pertinent patent fact to that got on Mount Rushmore. But in any case, and the other fact, which we'll just have to, my live audience here is kind of quiet today, the other fact I wanted to point out was that in the War of 1812, the British burned down Washington, did not burn down the patent office, because the examiner, the head of the patent office at the time, said this is important technology for humanity, and the British spared it. But yet by 1840, the United States was charging $500 if a British citizen wanted to file a patent, and only $30 if a US citizen wanted to file it. Today, interestingly enough, the fee for filing a patent is either $400 or $730. So you figure in those days how they really were trying to exclude Britain. The US was apparently not happy with them in 1840. Anyway, let's get on with the more substantive part of the presentation. This is the introduction section over here. Sorry for the quick flip over there. But this is the now the real introduction section of where we are. And basically today I'm going to be assuming that you have some familiarity with the patent process. I'm not going too much into basics of patents. This is a little bit of a higher level talk. But again, feel free to send in your questions at any time, and I'll try and answer them. And if you have more patent trivia, please also send that in. Let's try and liven up the presentation. So in the patent process, the first thing is the inventor comes to you with his idea. You then tell him it's no good. He then tells you he wants to do it anyway and hands you a check. And then you proceed usually with a novelty search, which is you find the what's out there, you do your own search, because the idea, or well, the patent, to get a patent, it should be new and obvious over everything. Some attorneys don't do searches. I tend to highly recommend them, because otherwise you're shooting in the dark. You want to know what's out there and what you can potentially file and what you can get. And then, true story, I actually had a client where I told her, no way, this thing is not patentable. I can't go into too much detail of what it is, but let's just say it was a way of picking up animal poop. And I said, this way of picking up animal poop is not new. And she said, okay, but I want to do the search anyway. I want to see you find it. She didn't say it quite like this, but I don't trust what you're saying. And I get this a lot. People think their ideas are great and wonderful. They come to you, they want to do it. So I said, you know, what am I going to do? Fine, I'll take your money. If you twisted my arm, I'll take your money. And I went and did the search for her. Lady didn't use email. All my clients I email. I do everything electronically. So I didn't want to actually get my fingers dirty and like pick up paper. Like, I should have a few papers here. Pick up paper, the chance of paper cuts, it's not worth it. So I found FedEx online. I was able to mail her a package. It was like $15 or whatever. Fine, I'll pay the $15. Mail the package out. You do it for me. And so I send her this FedEx package, and I say, here are 2 places where I found it exactly what you're saying. And I don't hear from her from 2-3 weeks. Then I get another package back, and she says, I understand this is your opinion. I mean, I showed her exactly where it was. And she says, I understand that this is your opinion, but I just want to see the patent office reject it. It was like wording almost like that. And attached to this was a big check to get started. So what am I going to do? Well, I didn't return the check. Maybe I should have. But I deposited the check. I wrote this patent application. Sure enough, it got rejected. It's not always as obvious as that. And then she wrote a letter back to the patent office, a 6-month deadline to respond. The very last day, she writes a letter to the patent office, and she says, I need a chance to find another attorney because his fees are too high. Give me more time. The 6-month deadline, the last day. It's too late. They don't give you more time. You miss a deadline at the patent office, your patent's abandoned. But anyway, I only found out about it because the examiner called me. I was like, what is going on here? You know, this is really unusual. Anyway, after that, you draft the application, you file it, and it's examined by the patent office. And where we are talking about is the arguments and amendments. This is after you filed it. You are now going to have the actual application examined. And basically, it works like healthcare. I mean, healthcare, I think in the days of Obama, now they're trying a little better to let claims through, but this worked a little better 5 years ago when anything I submitted for a healthcare claim was rejected and you had to argue it. U.S. Patent Office still works that way. Anything you submit is rejected. If it's not rejected, as my old boss used to say, you haven't tried to claim broadly enough. You're trying to get something too narrow. Patents are almost always rejected the first time. The examiners usually almost always aren't reviewed unless they're new examiners. It's not reviewed until second time at least, until it's final or until they let something through. There's no harm done for them if they reject the patent. Whereas if they let it through, now they can get into trouble and reviewed by others and so forth. So today, a first office action, meaning the first response from the patent office, which is what we're going to talk about, takes 1 year, 2 years, 3 years. It's gotten a little quicker lately. It was up to 5 years. It still is on certain types of business method patents. But the backlog has been kind of reduced. So with that in mind, there is also an expedited program where if you want your client's patent to be examined within 4 months, that's fine. It's basically as we would say when we took the exam for the patent bar, if you weren't sure of what an answer to a question was, you could narrow it down by choosing the one that included money. If it said pay a fee, that was probably one of the answers. So you want it examined faster, that's fine, pay a fee. There's other programs, there are other ways of doing it, but that is the main way right now, is depending on the income of the size of the client, the fee is $1,000, $2,000, or $4,000 for expedited examination. In addition to that is a petition fee, which is $130, and they've now taken away the publication fee, but in any case, you pay more money in expedited exam. In some cases you might want that, in other cases you don't. You might want it because you need to sue someone right now, or very shortly, or you need it for an investor. An investor is going to give you much more money of the issued patent. On the other hand, you're front-loading the costs of the patent prosecution when the client might need the money to develop the actual technology. They might really not need to worry about a patent for years down the road because they're just selling the products, and the patent issues, it issues, great, they're fine with that. So when you draft the patent application, we want to be expansive. The most important thing on a patent is the claim. So I have over here patent. These are all on my website, all my issued patents. This is the one I'm going to be talking about later today. This is patent 8,128,089. When I first started doing patent work, it was 2004. I was my first year in law school. I got the job over a secretary. Why? Because I could type 110 words per minute and I knew how to handle computers. And so the patent attorney, he was I think in his 70s at the time, he hired me instead of a part-time secretary. At one point I was crammed law school into 3 days a week and I was working 2 days a week, externship, and I had my schedule down to 15-minute increments. Thankfully today I work for myself, I set my own hours, I go home at 5 p.m. and it's great. You should work for yourself if you can. Send me questions about that. But any case, send me questions about anything. Send me questions about I don't know, whatever. The name of my first dog, actually don't do that, it's a security question. You can't have the name of my first dog because that is probably one of the security questions in my bank account somewhere. Anyway, why was I going on that tangent? Because this is patent 8.1 million, issued in 2012. Back when I first started in 2004, I remember we had just crossed over from 7 to 8 million, 6 to 7 million. Remember when patent 7 million issued? And then in right now, we're at about 8.8 million, approaching 8.9. I think I have 2 patents that are going to issue in August, and I think they're about 8,888,000 or so, which is probably the patent number to go back in time if you're Marty McFly, but I will not make any more Back to Future references because they are not funny. Okay. I use myself. Hard there's no audience here to know if your jokes are funny or you're just laughing to yourself. I don't know. Anyway, so in this patent we have the claims, which we'll be talking about later. Again, I remember what I was saying. You can find this on my website. It's patent 8129089. It's an automated bingo game based on RFID tag balls. That is the patent which I'm going to talk about today. And in the claims is the most important thing because that is what you are actually claiming, and everything else is just support for that. It's like people that wear those shirts that soccer is life, the rest is just details. The claims are the details, and that's the life of your patent, and the rest is just everything else. I'm not sure how to quite fit that with that soccer shirt, but it's sort of the opposite. But in any case, point being, you need to make sure you have support for that. You need to make sure that if you use words like substantially, you need to define substantially. You shouldn't, because if you say it's substantially round, they'll say, I don't know what substantially round is. Is that round? Is that not round? And they'll say, we'll interpret this as round, but you need to change the claim. So if the prior art, they go and find something where they find something that's exactly round, but not off round, whatever off round is, substantially round, however you would define it, then you can go and amend your claim, or you can go and say, I'm not claiming exactly round, that thing's exactly round, mine's better because it's off round. And then you have backup terminology and variations in specification in case you need to amend. So you don't know what's going to happen. It's sort of a little bit of a black box. The best of searching that you do, patent office will find some other reference they cite. True story, I had an application, examiner was Japanese. She went and cited 3 things from the Japanese patents that were in Japanese, and the client decided not to go forward on it. If they did, I got to pay for Japanese translations. She translated the abstract, the 1 paragraph on it, and you have to figure out what to do with this. And there's no way I'm going to find that. There's no way the client ahead of time is going to pay me to search Japanese patent office and know whether that exists or not. So you do the best you can, and you have a pretty good idea of what is and isn't going to get through. You sort of get a feel for what sort of things will get through, and sometimes they throw you curveballs, and sometimes things you don't expect to get through do get through. We'll be talking about that a little bit more. And the other thing is, since you write this application and you're often not actually reviewing the application for 3 years to get an office action, you sort of have flowers for Algernon scenario where you understood it when you wrote it, especially if it's a complex application. I have a client that's ground penetrating radar, and I kind of think I understand at the time I'm writing it. By the time I get back the office actions, you look at this, read all the claims that I drafted, I got to relearn it. I got to remember this again because it's not stuff I work with every day. So if you use the language, you support it in the specification when you can find it, and then I put the alternatives right in the specification, because if I need to amend something, there it is right there. I said over there it had to be, let's just say it had to be a wavelength of 500 to 50 megahertz, 50 to 500 megahertz, and now I'm going to need to narrow down that language. I'll put it right there. Well, in the alternative, it could be 100 megahertz. So if I need to limit it exactly to 100 to get around something that exists, something that was cited in the office action, it's there for me to do. So the other thing is, and you say alternate embodiment, you can say defined as. Using defined as is a very good idea. Almost all my applications, probably all of them, I use the word defined constantly because I'll say, it used to in the old days meaning 15 years ago, you would say things like, this is, for example, this could be thing A, thing B, thing C, or thing D. And I apologize, my 7-month-old has this detection mechanism for when I'm giving a talk the next day and knows to get up 5 times during the night. But in any case, thing A, thing B, thing C, thing D, and they'll say, well, thing A, thing B, it could be anything. You haven't really defined what your term is. You've just said examples. It could be any of those. And they'll say, well, I interpret this as this could be part of your terminology, even though it's not thing A, B, C, and D, it's thing Q, but thing Q is also this widget which you're talking about. So I say, no, I don't mean that. I mean it's defined as A, B, C, or D. And then if you want, you can put the next sentence, the alternative, we could use other things. But there, at least you have a definition to point to, and you can take that definition and you can actually read it into the claim, meaning you can add that definition to the claim later if you need to get around a rejection, while at the same time making the examiner feel like you gave up something and he got something, because a lot of this is subjective in terms of determining what is unobvious and what's not. If we knew that, we wouldn't have a patent system because we'd already know what's unobvious and what's not unobvious. So since we don't know that, it's subjective whether you consider something, hey, this is great, this deserves a patent, this doesn't deserve to be a patent. So, in any case, as Supreme Court case once said regarding 101 rejections regarding abstract, there's nothing new under the sun, patent, I'm sorry, that was the original quote from Koheles/Ecclesiastes. The Supreme Court turned it around and said anything under the sun, anything new under the sun is patentable. Well, what's new under the sun? And oddly enough, that's the reverse of the original quote, because what is new? It's all further putting together the things we know about. Now, if I smash this thing together with this piece of paper and it now cures world hunger, whoops, I hit the button, that we would consider new and unobvious to smash those together, but really I'm taking already physical properties, physical things that have been set into creation, set into motion, that are just continuing along that path we expect them to continue on, and we're just doing those in a new way, which if enough people wouldn't have thought about, great. And the interesting thing about this, you look back at things that happened like 10, 15 years ago, you look at like an Amazon patent, one-click patent was famous, it was in the news that they had one-click ordering. At the time, you can make a very good argument it's new and unobvious. Today, it's not new. Universal health records, another one of my clients, electronic medical records. It's patent going back 10, 15 years or something. We're still dealing with whatever, I don't want to talk too much, but still pending versions of it. And if you were to try and file that today, that's really difficult. Universal medical records, I mean, everyone sort of understands the concept, and trying to do that today is different than 10 years ago it was obvious. You have to look at what's unobvious at the time of filing. And there's another great case where someone has patented semiconductors back in 1970s. And back then, before 1996, I need to know this for exam, June 8th, 1996, I believe it was, when the law changed. Feel free to type in the comments and questions, correct me if I have any of these facts wrong. June 8th, 1996 was when we changed from 17 years from date of issuance was the term of your patent to 20 years from date of filing. Because what would happen, well, aside from doing what the rest of the world is doing, which the United States occasionally agrees to do, what would happen is you would have submarine patents that would just people would delay and delay and delay, get them issued 10, 15 years after they filed, because they cared about the term not right after they filed, but 20 years later. If you get a patent on a semiconductor today, you can sue everyone for infringing your patent that just issued. And the way this guy is trying to do it is he filed all sorts of continuations and different things, and he went and said, they never responded to this. I filed something back in 1979 on one of these versions, 10 different versions of his patent application that he filed. They didn't respond. They still owe me a response. I'm still waiting. They need to respond. And when they respond, since his filing date was before 1996, well before it, if he were to get that patent issued today, it would be good for 17 years from today. So he has a patent on a semiconductor for the next 17 years. That would be a big problem. Suffice to say, I don't think the patent office is going to let him get away with that. You know, I think at a certain point you have your due diligence to notify the patent office that they have not responded and so forth. Okay, let's move on. So it is still talking about the patent application itself. The background section, you can use it to discuss the prior art. Many attorneys don't like it. They don't discuss prior references, anything in there anymore, because it can be used against you. It's admitted prior art. But it gives you a chance to sell your invention to the examiner and tell the examiner what you're talking about, what it's all about. So you might say, in the patent that I'm talking about today, for example, there's a few paragraphs in it where we talk about the, you know what, I'm not going to pull it up because I'm not going to read it here anyway. So where you talk about what the problem is and what the solutions haven't been found for certain things, but you don't want to hint to what exactly you're doing. And it gives the reader an idea of where you're going with this and what this is for and so forth, which again can be used against you in court. You sue someone that's doing something for a totally different purpose. There's court cases where they then say, no, sorry, too far, they're not doing the same type of thing, even though they exactly read on your claims. And all this stuff is arguable. Court decisions are all over the place on patent decisions and so forth. Again, the summary, next slide, is optional. Generally, we track the claim language in plain English. This is what a court will read, jury will read to try and understand what you're doing, because it's in plain English. You don't use words like comprising or consisting of. And it's sort of closer to English than your claims are. All right, the drawings make your life easier. In the United States, I've actually had cases, you can't do this so much in other countries. In the United States, you can actually read in things from the drawings, put them into your application. True story, you can look at this. This is an issued patent on my website. This is all public data. I have a patent issued for a pacifier weaning device. This pacifier weaning device has 6 pacifiers, each with a smaller nub. The end part on it, I should have brought one here for demonstration. The nub gets smaller and smaller. And the idea is this, I don't know if this worked on any of my kids. My now 4-year-old definitely not. She would have known the difference. But in any case, you switch it out. The kid goes to sleep. Ostensibly, if you have a kid, you should take the pacifier out of the mouth when they're sleeping. We tried. Anyway, so my other kid's better luck. Then you replace it with the exact same one, but it's a little smaller, and they don't notice, and eventually it gets less and less nice because they have this smaller and smaller nub, and they're getting bigger, and it doesn't feel so good, and they get weaned off of it. You can look it up on my website, contact the inventor, license it, and so forth. This would be good for adults too. I mean, I still chew on pens and whatnot to this day. So you imagine if you replace it with a smaller and smaller pen, maybe you would get yourself off of chewing on pens. I don't know. It's probably my fault, my genetics, for where my daughters have decided they really like pacifiers. They have this oral fixation thing that I have as well, I suppose. Anyway, enough about me. Let's talk about drawings. Point being, on the drawings, what happened in this case was I had said that the circumference of the nub gets smaller and smaller. The examiner said circumference does not necessarily mean around the circle. He said circumference could be around anything. So he found a patent where the nub was pulled inwards. Like here's the nub coming out, and here's the back plate of the pacifier, and it was pulled inward. So each night you would pull it in more and more, or each whatever period of time, week, and then you wouldn't. The kid would also get the less enjoyment. And so he was right. I looked up in the dictionary. Definition of circumference can be around something. You could call this a circumference going around this thing, and that's silly. That's not the definition of circumference, but Merriam-Webster says it is. Every math class I ever took, I would have gotten the answer wrong if I said that in math class, but so be it. Patents are a combination of technical drafting and the English language as well. It's technical writing with the English language, and Absent definition, that can be done. So we read in from the drawings and said, no, we don't mean that. The drawings, we mean that it is a bulbous tip. We said that there is a smaller bulbous tip. That was okay. Didn't use that wording in the specification. Examiner said that's not new matter. You can't put a new matter in a patent once it's filed, except for continuation in part, which we're not talking about today. That's really a new filing anyway. So we read it into the specifications from the drawings which showed it. And it just makes it easier to understand. It's much easier to point to pictures. In fact, the one I'm talking about today, the bingo ball holder, I mean, here it is. Here's your circle. Here's your ARFID ball inside of it. Because why am I choosing that one? It's a really clean case. It's easy to talk about. The arguments are straightforward, and there's pictures. It makes it so much nicer, easier to understand. Method claims, if you say a method of using a ball selector and so forth, so now you use flowcharts and you try and match the claims, and if your flowcharts follow the method and so forth. And again, you can pull things in from there, and it just helps you, I think, in drafting the application. I draft my claims, then I draft my flowcharts corresponding to claims, and then I write my detailed specification corresponding to my drawings, and everything fits together all nice. Okay, issued patents, they used to be 1 to 3 pages. If you look at Abraham Lincoln's patent, which I mentioned earlier today, I believe it fit within that. I think it was like 1.5 pages. Okay, granted it was similar format today where we have the 2 columns, small font, but it was very small. The patent I have here is about 15 pages, including drawings. Back in the day, they'd have maybe 1 page of drawings, 1 page typed, and that would be it. Today, thanks to, I think, the aid of computers and the aid of the fact that we can type and edit and change things so easily, and the fact that society tends to get itself more complicated because we got more people, we got more technological advancement, we got to keep people busy, and court cases, they cite this problem and that problem. It's harder since there's so many more patents getting through. They're sort of narrower and more exacting in scope. More exacting what isn't being protected by your patent. So because of the more exacting nature of the practice, we put more in there because, as I was saying before, you don't know what you're going to need. You don't know what you're going to have to use and what you're not going to have to use. And when the claims, the claim gets rejected and you have something else in your application and you've put it in. If you're talking about a processor, the language of what is acceptable for quote-unquote software patents, which technically don't exist, but we claim methods that are carried out using processors and so forth, that language changes constantly. It used to change every 10 years, then a State Street case back in the 1980s, AT&T case, and so forth. And then finally we get up to Bilski today, and after Bilski we even have another case, Alice Corp, which was just issued a month ago by the U.S. Supreme Court. And what's happening is the language that we use to describe business methods, it used to be a storage medium, a tangible storage medium, processor, hardware processor. It changes from 10 years to 5 years, 2 years, 1 year, every 6 months now we're changing. For the Kurzweil fans, the business method patent singularity is near. Till we change it so often, it's like more often than you file the patent. So we put in all sorts of language, put all sorts of disclosure of hardware and the way the things work and how they fit together, because you don't know what you're going to need by the time the thing is examined, what the law is going to be. One of my other bosses, there was a patent I came to him with, and it said, we're drafting this application. I said, this was around the time of Bilski. Bilski, the CAFC, the Court of Appeals for the Federal Circuit decision just came out, and my job was to review it. The case with how the CAFC, it was a CAFC or BPAI at the time, the Board of Patent Appeals Interference of the Patent Office, how they handled this case was just ridiculous. It was complete with a quote from the Pirates of the Caribbean movie, and it was just anything but what I would call a learned legal opinion. Quoted things all over the place, and basically at the time was destroying business method patents like almost entirely, which some people are in favor of. For me, it's big business. I do a lot of them, so I'm personally not in favor of them being destroyed because, well, personal interest. Whether or not they're good for society or not, okay, that's up for debate. I think the bigger problem, getting off topic here, but I think the bigger problem with business method patents is things which will be obvious, say in 5 years, when the term of the patent is 20 years. So that's something that I think would be a way to address it. And in terms of like patent trolls, which are people who have legitimately staked out their territory and gotten their patents through, sometimes they're bad patents, in which case maybe they should be canceled if they weren't, but at the time they're new and unobvious, that's okay. But the problem is when the term is too long and and so many other people are using them. I mean, I think it should be sort of like what we do in the trademark system. American Express trademarked Gold Card. What happened after they trademarked Gold Card? Everyone and their brother with a credit card company, I mean, whoever's brother had a credit card company, mine's an electrical engineer, my other one's in IT, but no credit card companies in my family, they started using Gold Card. So now we have Platinum Card, and now we've gone down to Blue Card. I don't know how blue is better than Platinum, but all right, I like blue. It's my favorite color and all, but it doesn't make me think like, oh, that's more expensive and fancy than Gold and Platinum. But point being, American Express did not protect the name Gold Card properly. They lost the name. Anyone can use Gold Card. If everyone is treading on your patent, if it's so many people, it becomes so ubiquitous in the marketplace, at that point, that's when you have patent trolls suing every company under the sun. Like there's just certain companies that sue every computer maker, that it's like impossible to say, put a Wi-Fi card in your computer without infringing upon their patent. At that point, it should be, come on, this is pretty ridiculous because this is so ubiquitous in technology. At that point, maybe we should say the patent's not worth it. Now, how exactly we do that, I don't know, but that's my answer for how you solve the patent troll problem. If it's a valid patent, it's fine. If it's not a valid patent, because it's become so ubiquitous, sorry, person has lost the patent because we see it only took a couple years to become too ubiquitous. Now it creates a new problem. We need proper standards for how you determine what is ubiquitous and what is, no, that was a good patent, they deserve it. So maybe we put a minimum time frame of, say, 5 years or 10 years or whatever on the patent, and it can go up to 20, assuming it doesn't become ubiquitous. We might say, I don't know, in 80% of computers in the world, or something like that. I don't know. But I would move in that direction. So that's good. Let's go on from there. All right, claim drafting with office action in mind. I mean, I think I've sort of harped on this a lot already. So, but basically, this is going to lead into where we get into the office action. With the claim drafting, you make your claims count. Include novel variations and dependent claims. So in other words, if claim 1 fails, before what I said was, oh, you have alternate bodies in your specification, also have them in your claims. So claim 1 claims a widget having A, B, C, and D. It's this much. It's this much, and then claim 2 is everything, all of those things, but it also has to have E. So this is a little counterintuitive, but it's getting narrower because you also need E. Claim 3 might be everything in claim 2, meaning A, B, C, D, E, and it also has F. So it's more narrow because it has those more things in the claims. So now, if you don't lose if you lose claim 1, claim 2 might stand. If you lose claim 2, claim 3 might stand. Or on the other hand, if you say claim 1 has A, B, C, D, claim 2 has everything claim 1 but E plus E, claim 3 has everything claim 1 but not claim 2, because 3 goes directly to 1 also, plus F. So if A, B, C, D, and F, and then claim 4, A, B, C, D, and G. So now, if A, B, C, D falls, now maybe E will stand, maybe F will stand, maybe G will stand, and you'll get some of those claims. Again, you don't have a crystal ball to know how broadly the examiner is going to agree or not agree, or what he's going to find. So we want to stack the odds in our favor, and it's sort of about it. But I hate to admit on video that I've actually seen this, but yes, the odds are ever in your favor. I'm not going to say what I'm referring to, but the odds are ever in your favor is along those lines of you're going to get a rejection. No matter what, you're going to get a rejection. It's not like the movie where everyone's going to die, but you're going to get a rejection, and you are then going to try and stack the odds in your favor by having as many things for you as possible to get it through. Some people or some attorneys, it depends, for me it depends on the client, it depends on what their goal is. Some attorneys will fight every rejection tooth and nail to get as broadly as possible. When I wrote patents for a major telecom company, which I'm not allowed to name, unfortunately, I never signed a legal thing, but my old boss wouldn't be too happy with me. Then what we would do is they would fight it tooth and nail. They didn't care. It took years to drag on getting the patent. They'll eventually get the patent. It'll be broader. That's fine. They had lots of money to throw at it. I have other clients that just like get me the patent, and they sort of come to you like they've drank too much coffee in the morning, and they're all jittery and they're all worried and stuff. Like, what do you mean there's a rejection, and they can't sleep at night because you get a rejection? Those are the type of clients that you tend to be like, okay, let's get the client a patent, and then sometimes we do a divisional, a second application to try and get it more broad. Okay, moving on from there. Now, we're going to finally get into what is allegedly the subject of today's presentation. This is a crazy office action. This is now after we've actually filed the patent. Actually, we've given it to the patent office. We've waited our 4 months if we paid them our fee, our gangster fee to get it allowed. And oddly enough, gangster references work way too well when dealing with the patent office. I mean, the patent system in general. What are you buying? You're buying created in 1790 in a democracy where everyone is equal and everyone can do stuff, and the government is for the people, by the people, and so forth. The government is going to protect individual rights. What do we have out of that? Well, the individual right to get a patent. That's great. You have a right to get a patent, and now you have the right to use the government to break the other guy's legs. Now, we don't break legs anymore. Instead, what do? We get lots of money out of people. We stop them from selling the product. So now you can use patents to get the government to sue for you. So imagine you have the you have the gang on the Upper East Side. What do? He says every pizza place over there has to pay him money for protection. And now you get your business. You get your business there. You get that territory. That's yours. Anyone else comes to infringe upon your territory, he'll break your legs for you. The government, you can use the government action, pay a lot of money to lawyers, but that's because of the private sector. We've created a situation where lawyers get lots of money. But the government power will be used using its monopoly on that location in order to protect your rights. And if you want protection somewhere else, you pay for that protection. You pay the Canadian quote-unquote mafia, or you pay the European quote-unquote mafia, which they've joined together in one really expensive system to protect you in all of Europe. And that is more or less how the system works, is we use patents in order to use the government to protect your rights, and we pay them that fee. And but this is what happens. Because this is the government, sometimes you get something like this. The device of Claim 1, wherein said device is coupled to a neutral wire. So, it's very simple. Well, the part I'm saying here. Here's your device. Here's your neutral wire. Picture a neutral wire coming out. Office action, see Heart B. No further explanation. I guess he means figure 5B of the Heart reference. I kind of knew what the Heart reference was because there's an appendix at the end saying what patents they're citing at least. I like the figure 5B. There it is. That is, depending on your starting point of where you want to put your, no, I'm sorry, that's a cosine. That is a cosine curve. I remember my pre-algebra from the last time I think I had to remember what a cosine curve looked like. And the occasional patent, I use it, but anyway, cosine of 0 is 1, I believe. Send in the comments if I got that backwards. It's a curve. There's a signal, there's your amplitude, there's your time. I'm going to go back figure. Neutral wire, right? Neutral wire. I don't know, maybe a neutral wire is a cosine curve, maybe it's squiggly. I don't know. Anyone see that in there? Okay, the answer is no. There is no neutral wire in that graph. Now here's the funny part. Claim 2 was rejected by figure 5B. Claim 3, 5C. Claim 4, 5D. Claim 5, 5E. It was ridiculous. It was just setting each of the next figure. So after 20 minutes of back and forth, I had a telephone interview. Examiner refuses to discuss it. And I finally was like, come on, what's going on here? You cited this, there's no neutral wire. And he says, we don't have enough time. We don't have time to examine this. So I think examination has gotten a little better since then. You have good, you have bad, but basically this is what we're going to come into now, sizing up an office action. The first thing you get it, before you get too enamored with any arguments provided by the patent office, anything that they're doing or saying or whatever, we're going to figure out what's going on. So here's what they look like. On the left side of the slide is in the left side of the slide is the very right side of the cover sheet, and the cover sheet has the date that it was sent and so forth. And then on the right, it tells you what happened in the claims. This is sometimes a guide, sometimes it's accurate, sometimes it's not. You can get a feel for what kind of rejections there are and so forth. If you've done patent applications, you've seen this before, so I will move on. And if you haven't, well, you can just look at it. It just tells you the information. Now, I use a system called Docket Track. True story, reason I use this, hold on, water break. I have to look at this later to see if there's any like trademarks or things I can use during the talk. The reason I use one of these automated docketing systems to docket the dates is, well, one, docketing dates is ridiculously important. One of the major causes for patent attorneys being sued for malpractice is missing a deadline. And what baffles me is I've seen so many attorneys won't even notify the client when something happens for like a month, sometimes more. Sometimes they just plain old forget. Baffles me. If I get something from the patent office, I send it to the client right away. Right away, here's your office action, here's what's going on, I give some comments and so forth. I have a client that keeps ping-ponging between me and another attorney for whatever various reasons, and she wants me to look at it, this patent that he's filed, and I looked at it, like, it has a final rejection June 8th. Today is August 1st. I think it was June 8th. It's almost 2 months. You have 3 months on a deadline. Hasn't even notified the client of it. Like, what does he plan to do? You know, and she hasn't even seen it, hasn't been able to do anything. To me, that's crazy. I notify the client right away. And so a system like Docket Track, free plug, tell him you came from me. He promised me a nice credit if I get him some referrals, but I'm doing it not because I advertise things for other people. I, even as a kid, never wore shirts that had logos or things on them because I didn't want to advertise for other people, and to me it still seems silly if you're walking around with someone else's advertising. Well, that's free product placement for them. Wow, you should get paid to wear that shirt. You go to like Disney store and your kid comes out wearing a Frozen shirt or whatever, Frozen bag, they're walking it around. That should be cheaper, not more expensive. They should give you a discount on the one that has the Frozen logo because they should pay you to advertise. You don't charge more because you pay them a license fee. How ridiculous is that system? Anyway, that's enough social commentary to me. So I use this Docket Track system because what it will do is you can actually have the office actions or things, any documents that are not only emailed to you from the patent office, they're also emailed to this docketing system, which will then send you an email and tell you, hey, non-final rejection. In this case, it was, I can't read it from here and there's no Zoom, but in this case, I'm just going to make up a date. It was August 1st, 2014, and now you have a response deadline of, if it's August 1st, of 8 plus 3 is 11, it would be November 1st, 2014, and the final rejection date. And that puts it right into my docketing system, sends me reminders and so forth. So that 3-month deadline is important. And in addition, to make sure I notify the client, they get an invoice from me right away. And my invoice system is also, if I haven't said this enough times, I do everything electronically. I do everything electronically, and so they get an automated reminders of overdue notices, as now it's 1 month overdue and so forth. So they've gotten a lot of notices from me of dates to respond and whatever. And still, I mean, I've been doing this about 7-8 years now. Still, I've had, I think, 2 clients in 8 years that have said, oh, I was away for months. It tends to be, I tend to see this more with like well, whatever, we'll say this in a hopefully non-whatever, but clients that travel to India, they tend to do that. They'll travel for like a month or 2, and they'll come back and be like, oh, I didn't see these emails for months, and now the deadline is long missed, and now we have to do something about it, and I couldn't get in contact with them. Not saying all India, I think it also happened with a client in Thailand, or Thailand, Philippines, I'm sorry. That shows my American centricity in that, you know, the further away we get from our country, the less geography we know. Could be worse. That could be from New York, where everything past the George Washington Bridge in Verrazano is a just blur to you. Say to somebody from New York, I'm from Passaic, New Jersey, and they say, oh, is that near Cherry Hill? No, those are a 2-hour drive away from each other. To them, New Jersey is all the same thing. Anyway, let's move on. All right. Look up your examiner. This is something that I do. This is something new in my presentation for this year. There is a website called examinerwatchdog.com. It gives you a rough guide only, but some attorneys, people out in California, they went and found that it got the data from the patent office and started collating and giving it data. It's sort of like rateyourprofessors.com or one of those where you get ratings from professors. Well, that's sort of subjective, but it's still pretty good. It didn't really take off while I was still in school, and thankfully I'm out of school and hope never to go back. But in any case, I prefer to be working and not in school. In any case, this will tell you the data. It's not, I've heard things, it's not 100% accurate and so forth. It's also only published applications, not things that never published. But it will tell you, for example, if you're in Art Unit 3622, and Art Unit is the office within the patent office, here is Yadega Retta, and she has a 2% allowance rate. She has, out of 150 published cases, 3 have been allowed. And if I had to guess, it's probably due to appeals, because people appealed them and went over her head to get them allowed. I mean, invention promoters have better records in this Art Unit, meaning these guys that say, don't worry, it'll be fine, pay me $10,000, $12,000, we'll market your invention, we'll, whatever, and so forth. Those guys, they don't make people money. Interesting side note, Popular Mechanics, you can find Popular Mechanics magazines on Google Books. They're all available. If you look back in the back of them from like 1930s and 20s where I was looking at, even then you see these scam artists advertising in the back of them that we will give you patents for whatever it was, $99, we'll do your patent search and whatever and so forth. Lowball rates, same thing you see today, and they don't produce much. On the other hand, I billed the client my regular rate for a search. He was a barber, and he was very mad at me when I gave him back the search. I worked with him a lot to find a way to make his thing patentable. We had to do variations and stuff, and I didn't charge him more, and I thought, hey, I'm doing a really good job for this guy. And he came back to me and says, what do you mean? I thought you're doing the patent also. You mean for that price you were just doing the search? I could have gone to these other guys on the internet and they charge $199. Like, you're not getting the same thing for $199. I went back and forth with him, make him happy, make him understand, show him some articles on what patents cost and all that type of thing, and say, no, this is my regular rates and so forth. These are normal rates. In fact, if you go to a big firm, I'm ostensibly a solo practitioner. I have 2 associates as well, but 2, I guess, part-time associates. You can pay triple, But in any case, that's a different story on what the rates are out there. And then on the other hand, if you go into Art Unit 2835, you'll see, I'm not going to pronounce the name of that. You can read his name on the slide. This is really his name. But that is his name of the examiner. He has a 92.3% allowance rate. He's been there forever. He has 746 cases. 671 of them have been allowed. And most of his Art Unit is like that. So you want to look up what Art Unit 2835 is, see what it is, and if you can, you draft your patent so it falls in 2835, not 3622. Because as silly as that is, as it's supposed to be, you have the same examination regardless of where you go in the patent office. It's simply not true. It's simply not the case. And the last time I gave this talk, someone asked me, like, did you ever notify the patent office about this? Do they know about this website? The answer is, now they do. I spoke to, when one of these cases I was having real trouble, I spoke to the ombudsman's office, which helps you more with like procedural things, and I spoke to him and I said to him, this guy doesn't allow anything through. I just got a really bad examiner. And he said, no way, how do you know that? Showed him the website. He went on, I showed him the Art Unit. I'm like, this is impossible. The Art Unit with the next number up, so it was 3612, this was 3613, and I'm like, look, these guys allow 40% of their cases. I understand business methods is difficult, whatever, it's a lot of rejections, but to go from a 0% Art Unit to a 40% Art Unit, because my client got a bad draw on the lottery and which Art Unit it got sent to, that's just not fair. And he's like, well, nothing I can do about this, but wow, that's really interesting. Let me see my Art Unit. Look at my Art Unit. So he told me his number when he works in. He's a supervisor of a different Art Unit. And he's like, I'm like, yours is pretty good. Yours is about average. Like, patent office 40, 60%, that type of thing. Many of those are individual inventors, don't know how they're filing, things are rejected out of hand, people don't respond, they give up on things and so forth. But in any case, but you got this one who's got like 9%. He's like, I knew I had to get on top of that guy, but I didn't know he was that bad. So I think it does have some of an effect. I think, maybe this will backfire on me and we'll be saying the opposite in a few years, but I think the patent office should know about examiner watchdog and know about when examination is just simply not fair. And in a not fair case, now you'll know it and you'll know it's not you. I don't have to feel so bad on days when I get terrible rejection because hey, maybe it's not me, I can look it up. Versus but on the other hand, if I get something through, now I don't pat myself on the back as much, like, oh, good job, look at that, I had such a great argument, because, well, the examiner lets everything through. So, whatever, that's the system. Most of them are in the middle, though. Most of them are not 2% or 92%. All right, so you get a reference. First thing you do, check it. What's the filing date? What's the earliest filing date? There are attorneys at big firms that do not look at this. This is real case. Just recently I was doing a claim chart analysis. Client is in litigation, and he wants me to do a claim chart to check on patents, whether it's infringing and so forth, whether these prior references are valid and so forth. And the first thing I do is I look at it, and it's like, oh, no one ever told us to look at that. Could save them a lot of money or make them a lot of money. This could be worth millions of dollars in lawyer fees and litigation, whatever else, if you figure out the fact that, no, this is not a valid reference because it's actually filed after your provisional filing date, or even if, until the law changed in 2013, or even if it's filed before, you can, quote, swear behind the reference and show you were working on it earlier. And if you were working on it earlier, then as long as you have proof of that, you can say, no, that's not a valid reference against mine because I was the first inventor. Today, since 2013, we switched to a first-to-file system, but you can still do that before 2013, which is why patent history is sort of good to know, because you understand these changes and when things happen. Okay, knowing Abraham Lincoln got a patent isn't really going to change your prosecution today, but knowing the date 1996, 2013, other famous dates in patent history that we need to know can make big differences when the law changed. Review the examiner search history. I do this a lot because you figure out, is this a quality search, first of all? Did they spend 5 minutes? Did they spend 5 hours? Did they come back to this 3 times because I can see their supervisor or somebody told them they weren't happy with it, they had to search more? And you can get lots of clues there. The reality is, most first office actions are poor. They're not reviewed by anyone other than the examiner, unless it's like an examiner within the first year. And a lot of times people don't respond to them anyway, so they don't put the most amount of time into them. But then you talk to them and then you sort of negotiate to get what through. If it's really poor, it tends not to be that bad because it's just sort of they're giving you a rejection and you can be able to work with them to get something because they probably think there is patentable subject matter there. If it's really good, hey, I like that too. If it's really good, I know what I have to work with at least. I know what the arguments are, and hopefully you've counseled the client that the clients say things to me. I want to guarantee this patent's going to get through. Said, I'm sorry, I'm not giving you a guarantee. That would be malpractice. That would also probably be a lie. I can't guarantee. You don't have a crystal ball to know what's going to happen. But so as long as you've counseled the client, have reasonable expectations on the patent, maybe it gets a little more narrow through. I can tell them, reasonably speaking, I expect this amount to get through. Reasonably speaking, I expect this type of thing to get through. Reasonably speaking, the allowance rate over there on these type of patents is 80%, and my allowance rate over there, say on medical devices, is 100%. So I think a good new medical device, I'm going to get that through. Now, if he says, oh, I just want to take this and bend the tip a little more, maybe get that through too, but that's not as good as say, hey, here's a totally new device that you're probably going to get through. Check for what's going on, 102, 103, 112. I'm not going to go into that. I'm assuming the people who are watching know this. If not, watch one of my other videos on my website, patentlawny.com, where I talk about more intro-level stuff. I'm also, if you're watching this live, want to see me live, I'm speaking on the more basic talk. I give talks for SCORE also, which is retired business people. I'm hosted at some of their talks to tell people how to get started in business. And I talk about patents, trademarks, and copyrights there. My next talk is August 13th in Maywood, New Jersey. Any case, now when you receive your first office action, well, hopefully it's formatted better than the dots on this slide, but in any case, something happened in the conversion, whatever. Everything in my office runs on Linux, which is great, except for when you convert it to PowerPoint slides for the presentation like the rest of the world uses, and it changes your formatting of your dots a little bit. But in any case, I'm probably the only law firm to be running Linux. In my previous lifetime before becoming a patent attorney, I used to fix people's computers, and I've been a computer nerd since I was like 5 years old on TRS-80s. In any case, so now you decide what to do. Do you send it to the client without comment or review it first? Depends on the sophistication of the client. Some clients, boronization of titanium. My client is the foremost world expert in boronization of titanium. I don't know how many people boronize titanium in general. I send it to her and I say, look at this, tell me what you think, here's the references, let me know what's going on. If I have another client where it's, say, a cook handle with a collapsible handle, and it's very technical language in terms of the patents that are cited against it, of exactly how the things interlock with each other, and the client doesn't, he's not that into it. He's into just, get the patent on my concept. I'll say, I got to do the review first, let me do the review and so forth. And I usually, just as a practice thing, I break it up into 2 steps to make it smaller chunks of money. I mean, depending, bigger clients are different. Bigger clients, you send them a bill and whatever, they pay. So I'll send them do first invoice, and I'll do a review of the office action with the examiner interview. I always do examiner interviews because statistically you get much better, you can explain it better. You can, one-on-one, as opposed to if you're just reading this paper and trying to figure out what he's saying, and then now he's reviewing your paper back, versus face-to-face communication like I'm talking to you over here. Now you can understand what I mean better. Otherwise, they wouldn't require live or video CLEs. They would say you have to read a book once a year and take a test on it. That's actually the way they kind of used to do things. I remember my father, who's a physician, read books and take these tests and send them in. That type of thing. I mean, that's another way, but videos and whatever, audio at least, there is now video conferencing with the patent office. It's limited, but audio, at least talking to the person to get a sense of their arguments, understand their arguments, and get it through better. And how well do you understand the technology yourself? Now, if I was also a world expert in boronizing titanium, then I would say, come on, this is not it. Boron carbide with aluminum oxide, that's what you're citing against me? Who uses aluminum oxide when you boronize titanium? Come on, what are you thinking, examiner? Okay, I don't know if that's true at all. Well, aluminum oxide, apparently it makes it more porous. You don't want to do that, but that's a side point. But if it's something like, I have a client, this is a great case I got through. So this was a motherboard inside a case, and on the other side of the motherboard is all of the cables. So basically, I've been opening a computer since 3rd grade, 4th grade or so. You open up the computer, so you take off the case, the side that slides off, even on today's tower cases. There's the motherboard, mess of cables all over. Cables going to disk drives, cables going to the between the motherboard and the power supply, and so forth. So with this client, he's a high-end computer seller. I don't think he'll mind the shout out. Main Gear, you go to maingear.com. He sells high-end gaming computers, good stuff. So what he's developed is all of the cables are on the back side. So you open up the computer case. Now here's your motherboard. You see a clean motherboard, probably some nice LEDs and that type of thing. All of the cables run around the back side, plug in the back of the motherboard. So all the cables are between the case of the computer and the motherboard. You see a nice clean thing in there. So it's a look, it's a thing. It doesn't really change, as far as I know, the functionality of the computer as much as the aesthetics. Now in this one, I got rejection after rejection, and she could not find a good rejection. And so this is an area I'm so utterly familiar with. It was something where like a line was hand drawn and scribbled over like the disk drive, and disk drive to the motherboard, and said, oh look, that goes behind it. I'm like, come on, that's just a scribble on a line. And in that case, the motherboard was floating inside the computer, and it was like not even a full computer drawing. It was like, you can't tell anything by that. And I'm like, I was like laughed at this one, and I'm like, here's the response. Here's what it is. I'm like, Sam, don't worry about this. I'm just gonna do this. I don't need your comments. I'm just writing this up. I think that was my fastest office action response time, because what I decided at that time was I just wrote the response. I just looked at the 2 rejections. You can't always do this. And I just started typing. In 2 hours, I had the response done, and I filed it the same day the office action was issued. And sure enough, I got it through. Eventually, the patent office gave up. They did not want to allow this case through. And I don't blame them, because it seems simple, but if it is new and it is unobvious in the prior art, they can't show it in the prior art. Hey, that's patentable. And sure enough, that patent issued. You can find it on my website. And we had a good lunch with the client after that one. Very happy about that patent. And we got that through. So anyway, office action summary. So you may want to take the allowed claims to protect them and file a divisional application for the rest of them if you see that some of them are allowed. Or you might just want to argue if the client's not happy with the claims which have been allowed so far. If the office action is final, I've had varying success with different examiners. I found some examiners are great. They're really nice people. They're very helpful with you. They'll work with you to help you figure out what you can claim, what not. Other ones, they won't do a thing for you. Other ones, you get the final, they won't talk to you, and so forth. There is an after-final pilot program, which I've had limited success with. Some examiners will accept into it, and some not. I think they're probably going to make this program stay because it decreases the amount of times people file continuations, and they keep all these things in the queue. It helps the patent office get the backlog down. And basically, if your patent is near allowance, you can narrow your claims. It gives the examiner more time to review it and do a search. And if so, then they can go. Then you might get the patent there. I have had patents issued that way, and I've had patents not issued that way. I've had examiners force you to file a request for continued examination, and then they examine it right away after they do that. It costs you another fee with the government, but they get more counts, more credits for the time that they've spent on things if it's a response after a request for continued examination rather than after final, because it allegedly took them more time. It's the system, it's the government, we deal with it. I can't say I would be any different if I worked for them, and that's how the system works, and that's what I had to do to meet my quota, and this is what was developed. Again, everything's supposed to be fair, everything is supposed to be right, and for the most part, U.S. government, it's the best government in the world. It's still highly, highly problematic. We have a deficit which is ridiculous and growing. There's lots of problems, but it's the best thing we got. It's kind of like dating. There's no good. Every dating system we have is terrible, but some are better than others. So that's kind of the way it is. So, prior art rejections. So now we're going to get into the actual substance, the meat of the rejections in our last half hour here. So, goal, break it apart into manageable pieces. Here's the problem. You get this office action. You get 10, 20 pages. Rejection, rejection, rejection all over the place, citing 6 different references, saying he puts them together and so forth. So, don't look at that. Who cares? Don't look at what the examiner says. You're going to get tripped up from it. Now, know what your argument is first. So I've developed, this is a systematic method in order to know what your argument is and know how to go through the patent office in a way which is basically, you're going to understand your own arguments, understand what you can do, and understand what the prior art, does it really have that or not? And then when you look what the examiner says, you'll know whether he's right or not. Is he examining this correctly or not? In that claim chart I just referred to give a corollary, I was reviewing it. I did a claim chart for 3 patents cited against my client's patent, and he had given me the claim chart from another attorney. And what I said to him is, I'm not going to look at this claim. I'm not going to look at the claim chart from the other attorney. I'm going to do my own first. After I'm done, I'm going to compare. And that's what I did. And because I didn't want to be tripped up by what that person said. And you know what? We were the same except for one point. And it's one point which is a split in how the courts interpret language. If you use configured to or adapted to or in order to do something, it's questionable whether that will be interpreted as breathing life into the claim and as something which is required in order to infringe. All right, so 1, when reviewing systematic order, refresh your memory. Review your patent application and your claims. So basically, know what it is. And what I do here is, this is going to be in the office action anyway in the response, write a paragraph. Don't just copy your abstract, that's cheating, that's not going to help you anyway. Write a paragraph tailored to the parts which are relevant to the citations. Say, my thing shows a ball selector with RFID balls. The RFID balls are freely movable within each, the RFID transmitter, for those who don't know RFID, that's Easy Pass. For those of you on the left coast, that's Fast Pass, that it uses RFID. It's basically a passive transmitter. When you transmit to it, it transmits back. Radio frequency identification tag is what RFID stands for. If you use a term like RFID, you need to define RFID. Don't just say RFID in your patent applications. You can say RFID, but in parentheses somewhere you put radio frequency identification tag. So we'd say this is a ball that is freely movable. I'll show the picture again from the patent up here. It's a wire version of, say, a ping pong ball. There's the RFID in the middle of it. And basically, mine freely moves in there, and I describe that in a paragraph. And the reason I do that is because I want to know what it is. I write it. I force my associates to write it in order that they understand it and have it in their mind first. Now, look at what he cited. Don't look at what he says, just the references. So he cites Huang in view of Goldstein. Huang and Goldstein cite different things. And I say, oh, Huang is talking about ARFID balls. Goldstein is talking about bingo in general. And I write a paragraph of what they're talking about and what they show and don't show. Now, basically, this should be about an hour exercise. When you have a new associate, it takes them, say, 15 hours the first time, then 10 hours, then 5 hours. They finally get to about 3 hours to do this exercise, and then they leave you. Anyway, so this is an example of what I just said. This is in the slide. Since I just went over it pre-slide, it's here if you want to look at it. But basically, a spherical ball with internal transponder, freely movable, is how I described it. And this prevents the ball from getting lost by rolling away, so transponders are constantly working against the rolling. Further, as recited in paragraph 39, and you keep giving citations. Citations and quotations are your friend, because if you go and say, oh, well, my thing cures cancer. Well, if you don't have any specification it cures cancer, examiners are like, that's very nice, you developed a device to cure cancer, and it's so much better because this ARFID cures cancer, the other one gives people cancer. But you haven't cited that anywhere, so I don't really care. That's not in your claims. Most important has to be in your claims. You cite things that are in your claims. So here is the prior art cited. In this case, it was U.S. Patent Application 2. Sorry, it wasn't Huang. It was Ito, who, by the way, as an interesting historical tidbit, this is something etched in my brain because I was in 8th grade at the time. Judge Ito was the judge who heard the O.J. Simpson case. And Judge Lance Ito. And one of, there's a few places where you remember where you were at the time. I remember I was when the World Trade Center went down, and I'm blocks from it right now, from the new tower. World Trade Center for a time. I won't go into the World Trade Center trademark issue, but that's an interesting issue, for me anyway. But I remember World Trade Center. I remember, I don't know, let's go for a high school graduation, and I remember where I was in gym class when the teacher ran away when he had the headphones and decided he wasn't going to tell us until we caught him whether O.J. Simpson was guilty or not. That's what we have in our historical memory. Like people used to remember JFK, where they were when JFK was shot. I remember where I was when O.J. Simpson was acquitted. Any case, figure 3 refers to an ARFID tag fixed to a plane passing through the center of ball 2. So you can see it on the slide there. It looks like it's fixed. I can't tell if it's freely movable. Here, this thing is a round thing floating around. Interestingly enough, we made it round because there's a lot of bingo regulations. For bingo, you have to have an equally weighted thing because there's a worry if it's not equally weighted, you can cheat. Cheating at bingo is apparently a big problem. But in the prior reference, there was no disclosure. You can't tell in that one. Is it freely moving around or is it stuck in that position? I don't know. And you know what? You can't tell. So the truth is, I looked at I looked it up. I found the company that was selling these things, and I'm sorry, it was different than, I don't know if it was related to this patent application, but I did find them being sold, and the ones that were sold were solid. And I think I had found that before I even filed the patent application, which is why I did it as freely movable to begin with. And sure enough, that was cited. It was a good citation, but didn't cut it. But now we've reviewed our claims, we've looked at the prior art itself, whatever, and we've picked out differences in the claim features. So now I know exactly where I stand. I know, oh, hey, I wrote that. We're now clear on where we stand. So I know, whoops, as I fall over and lose my balance. I know where I stand. I know what's in mine. I've written a paragraph. I know what's in the prior art. Sometimes it's not always so easy, or you're dealing with minutiae of things, but only now, once you know your own self, quote Shakespeare, to thy own self be true, or to quote any self-help book, know who you are and don't let other people tell you who you are. For example, what's the point of being angry at someone else for doing something? No, you're in charge of your own emotions. Don't be angry. What? You're angry, so you're letting them control you? You don't like them. You don't like what they did to you. You control yourself and don't be angry. Worry about yourself. Build your own self up. It's basically 2 ways you can do things in life. You can do it the lawyer way, where, someone comes in and they're disgruntled and they're hurt. Hire a lawyer, hurt the other person. Or you can do it, my wife is a social worker, therapist. If you need therapy in Passaic, New Jersey, her office is there. Family, marital relationships, depression, anxiety, that sort of thing. Free plug for my wife. She's very good, too. Anyway, then what do? You build yourself up. So in our profession, we knock other people down. Not me, I'm a patent attorney. I don't know enough law to hurt anybody. But in the therapy profession or a doctor, you build yourself up. You heal yourself. So now that we've healed ourselves and we understand who we are, now we're so much stronger. Now we don't have to get upset, emotional, angry. We can look at that and now we can see what's going on in the office action. So now that I understand what I'm doing, I use the LOTA method. It's self-named method because it's an acronym. Acronyms are good things or something. And limitation, office action, text, argument. What's the limitation? Copy and paste each limitation. I want to know what the limitation is. So, for example, in my claim, I have a plurality of balls in a chamber. That's one phrase. That's one limitation. What does the office action cite? I actually copy and paste it in. I will take the text of the office action and I will paste it in there so to make it nice. If there's a software application out there that does this for you, that would be wonderful because it would save me some time and billable hours. And I suppose I want more billable hours. No, actually, I guess it's okay. But in any case, so you copy and paste a limitation. And then you copy and paste what the office action says. Now I copy and paste the text. Now I've got it 1, 2, 3 right there. And then I figure out an argument. Does that match or not? Now, if I do this line by line, I already have in mind what's going on. Now it's very simple and systematic method. You don't have to do it my way. This is just the way I develop. Nobody taught me this. Usually, you get your first job at a patent law firm, assuming you can find one. It's hard to break into this field, but you get your first job. They say, "Here's an office action. Here, they stick this on your desk and say, come up with arguments, respond to it." You got to figure it out. Sink or swim. Some people figure it out, some people don't. Thank God I figured it out, but I developed a system and here I am teaching others. So the way it works is if it's a 102 rejection, it's in one piece of prior art. If it's 103, it's in multiple pieces of prior art. So the way I handle it is, remember, each and every limitation has to be there. If each and every one isn't there in the prior art, it's no good. And they have to at least put each of those factors there, even if they say it's obvious by combining references. I don't so much go into arguing that things are not obvious when they say that they are. You can argue that. I find that's very hard to win those arguments. You say, no, it's not. They say, yes, it is. They work for the government. You don't. They don't need you for anything. They tend to win those type of arguments unless you can find clearly it's teaching away, or clearly if I combine a paper with a laser pointer, that thing is not going to function. You can't say I combine those to come up with those things because they don't function that way. So here it is. Here's an example. Carrying out the LOTA method iteration 1. So this is my first limitation. A generally spherical encasement with a hollow interior. So the way it works is, now I have claimed, in my claim there's a limitation. Generally spherical encasement with a hollow interior. In other words, I have, not what the picture is shown there, this picture again, which I think I actually did this drawing myself, but in any case, here is the spherical encasement. I think I got these off of Google Images and threw them together. And here is the hollow interior. So we're not claiming this yet, just the hollow interior. The office action says, each ball comprises a spherical encasement with a hollow interior, see figure 3. I looked at figure 3, and there's that picture you saw above. Okay, so in this case, there's no text, it's just pictures. Is that interior hollow? I don't know. I can't tell. So my argument, limitation, office action, text, now we're up to argument, figure 3 is not enough to show hollow. I do not know if that is hollow. I just see this thing, this wafer thing, which was an RFID tag as best I can recall, inside a ball. But it says it's a resin ball, so I started making arguments saying resin balls typically are not hollow. If you make something of resin, you're probably going to make it solid, and so forth. And so now I have my whole argument ready for when I conduct the examiner interview. And sometimes I even just give these analysis to clean it up and give selected portions I give it to the client first of all, so he can see what I'm doing and understand and look at my arguments. And I highlight the parts that he should read. I highlight the parts where I'm like, look, we got a really good argument here. So, he sees what I'm doing and understands it. I'm a big believer in good client communication, talking to the client and then telling them everything. They understand the process. They're happier, I'm happier. You don't get sued because, even if things go bad, the main goal here is not to get a patent. Getting a patent is like plus 40, plus 40 points on a 100-point scale. But the main thing is to keep the client happy. If you have a client happy, if I tell a client this isn't getting through, there's not much chance of getting through, but he sees I put in good effort and he sees I really tried and he sees the arguments and he agrees with me that, yeah, we can't overcome these arguments, he goes away not ecstatic, but he's not mad at me, and we go on, we file another patent, I get him another patent. And it's happened to me. I have clients where a client where he didn't want to do a search. I recommend he do a search. He didn't want to do it. He did an expedited filing. And I think I drafted the application well, and he said, no way, this is not there. They'll never find this. It doesn't exist. Sure enough, it came back. Patent office found it. It's extremely similar. We got a rejection. Sorry. But you know what? He keeps coming back to me. I keep doing more work for him. But now he trusts my judgment a little more. The last one I did, he hired me to do a search. Now I do those searches. So, it's building up that, and to keep the clients happy, and when the client's happy, the client understands. Even if he's not happy, we've had good client communication. So now he'll trust me a little more, and now I have a good client rather than a client who might have gone elsewhere or not filed anything. All right, here's another one. Near field communication reader below an exit tube. This was also my claim. So near field communication reader below an exit tube. I will hold up that picture here. So I don't know how well this shows, but you can download this patent off of my website, patentlawny.com. Here is your bingo balls. Here are your balls coming out. The near field communication reader is down here below the exit tube. So the examiner, the office action, copy, paste. Ball selector also comprises the near field communication reader, antenna 48, which is below the antenna, below the exit tube, ball recovery box, paragraph 67, blah, blah, blah. I looked at paragraph 67, it's not there. But you know what? I didn't bother to say, gotcha, it's not in 67, because he'll just come back with another rejection and say, gotcha, final rejection is in 68. So, on quality between the patent office and you got to worry about your own quality. Patent office has to worry about its own quality. Your private pay, your clients coming to you, and so forth. And anyway, so I find it, and now, where do I find it? Paragraph 68. The antenna 48 is disposed between rotating discs 45 and 46. Found it. There it is, 48, and it is going all the way around. So I might say disposed only below or something like that, but that's not disposed below. We're measuring RFID like around the thing in this reference that's being cited. I'm talking about below the exit tube, not around the whole thing. So, limitation, the reader or the antenna, same thing for practical purposes here. I'll give the examiner that. The reader, it contains an antenna. I'm not going to argue a point not worth arguing. I only argue the points worth arguing, and I argue all of them, because again, you don't know which ones are going to be successful. So the reader is below the exit tube. The office action, not true, but it didn't even cite it properly. But I did find it in the prior reference. We care. Your thing needs to be new and obvious about everything. Whether the patent office cites it or not, you need to know it's new and obvious. For an office action now, rejection was for some silliness, for claim language, not for anything substantive in the prior art. But I know I got a search in Europe. In Europe, they cited something, and it did read on my independent claim, my main claim. And so even though I could get broader claim in the US Patent Office, it's not worth it. I'm getting the same claim I'm getting in Europe, because that goes to litigation. They're going to say, oh, tell us where else you filed it. Look over there. It's narrowed. Your US patent, it's not worth it. It's not worth it anyway. So we get the broadest claim, which is allowable, which you can actually sue someone for infringement. Unless you just want to say you have a broader claim to scare people, I suppose you can do that too. Text shows antenna and a coil around the ball. It's not under the exit tube, so I made the argument. This prior art citation does not show a reader below the exit tube, because the reader is actually around the ball path and above the exit tube. So, in other words, the argument is, I cited, here is tube, here is my reader below it, prior art cites, here is tube, here is the reader, actually it wasn't below it, it was probably like this, around the left and right side on the top. It's not the same thing. So those are my two examples of providing this method. Now, basically, you keep doing this, you repeat this LOTA method for each iteration, you iteratize this. You go through the iterations of each and every one of your limitations. Now, some of them, for example, if you look at my patent 8,128,089, which I'm referring to, I say a randomized ball selector, the first thing is comprising a video screen. I don't talk about a video screen. The patent office has to find a video screen somewhere and say, hey, this video screen, there's nothing new about that, move on. Move on to the points which are really patentable. So you might just pick out the limitations which are useful. So a plurality of balls in a chamber, each single ball comprising a hollow interior frequency identification tag therein, that sort of thing, that has something there, that has weight to it, you check on that one. Radio frequency tags having unique indicia stored thereon. I kind of knew already that these tags existed, so I didn't expect to find balls that didn't have unique indicia on them, so you can sort of skip that and you go on to the ones which are important limitations, and so forth. And then those are the ones you focus on for your analysis. It's best to be more expansive than less here, to look at more limitations, but look at each one singly by itself and see if it cites it. And once you have that, and you have your high-level notes of what's in yours, what's in the prior art, your work is basically done. The rest is just now talk to the examiner, and after you talk to the examiner, put it in a formal response, and you have really good arguments. To the point where I had an examiner interview once for the examiner. We just went, point 1, point 2, point 3. Here are the points. Here are the arguments. Here's my analysis. They gave him a copy. He's like, whoa, you're so prepared. Usually, attorneys just call me. They just call me and whatever. We just start discussing, and they just sort of how about this, and they just sort of have like all these discussions. The talk where I spoke to the National Association of Patent Practitioners 2 weeks ago, and gave a similar talk to this. Also, it's a annual meeting of patent attorneys and patent agents in Alexandria, Virginia. And the guy who presented before me said he spent 4 hours on an examiner interview. I was like, whoa, 4 hours. I didn't know they had that much time allotted. I allot an hour. Typically, I spend 15 to 30 minutes, what's needed. Here's the arguments, here's what we can do. Sometimes they go longer depending. Another examiner, I called her, and she was on vacation in Maine at the time, and she really just wanted to get off the phone, have the examination, and we had it, and she's like, okay, yeah, I understand your points. Yeah, you're right about that, you're right about that. Yeah, just modify it, modify your claims, add that, and that in. So many times we modify the claims. Even if you're right, you can be right and lose. You can be right and unhappy, or you can be wrong and happy. So you change your claims a little bit sometimes. You modify it, you include more definitions, and the examiner will say, yeah, okay, I see how that's different than what I cited, and they feel like they got something rather than going head to head with them. Other times, depending on the technology and the client and so forth, you might want to go head to head and say, nope, I'm not backing down till you accept that, but you might have to keep filing continuations or threaten appeals or that type of thing. All right, now we're going to talk a little bit about the examiner interview, which I just started going into. In the examiner interview, adequate and good manners are critical. I can say there's one examiner that I did get upset at, and I can also say that got me nowhere. If you do things like you pre-appeal on them, they will not be happy. Unfortunately, sometimes you need to do that. But statistics do show shorter prosecution and greater allowances when an interview is conducted. And, most of them are very friendly people. Some of them English is a second or third language, but even that's getting better. I think prosecution on a whole is improving at the patent office in the last couple of years. It's still, you get bad office actions, you get good office actions. But it's easier to explain with the give and take. I discussed this before. And you can understand the examiner's position better as well. Because sometimes I just didn't understand what their point and what they were saying. And so just by discussing it, it helps understand. And basically, the examiner interview, as long as you've done your homework, you've done the high level and the LODA analysis, so now you're all ready to discuss. You know your whole argument. You don't have to sit there futzing and figuring it out with the examiner. So be prepared with claim amendments. Most times examiners want an agenda or proposed claim amendments beforehand, and be prepared to explain the difference of the prior art and be able to articulate it. And if you can articulate it and you can get them to understand, most of them are human beings. Some of them are robots. Sorry, most of them are human beings. I had to reboot. I don't know if anyone's laughing or not because I can't see you, but can you guys delete that from the video? Thanks. Okay, so most of them are human beings and will understand your arguments. Sometimes if you're in like business method patents, doesn't matter what the hell you argue, they're still going to reject. Those are the ones that I talked about way back in the beginning, the 1% to 2% allowance rate. Just, you get one of those guys. Basically, you can't get a new examiner unless they're said, if you pay me $5,000, I'll let this through for you. Short of something like that, which to my knowledge doesn't happen, then what you need to do is just get your claims in order, deal with all the procedural issues, make sure everything is in order properly, and plan to appeal, because you're going to have to appeal those cases. All right, no sense of getting mad about it, just prepare it for appeal, get everything in order. All right, and then you write the response to the office action, which basically has cover sheets, amendments, arguments, declarations. The declaration is like test results, swearing behind a reference, which you can't do anymore anyway, unless your thing predates to 2013. Then you put it together. And here's what it looks like. Here's the cover sheet. So here's the heading. I blocked out some stuff, although this is actually a public document. You can, if you really want to, you can look up this application and you can find this in the public record. And you state what it is, you state what each page it starts on, the interview summary, mems to the claims. You have to write an interview summary if you conducted an interview. I actually just had a notice of non-compliant rejection because I didn't mention the interview summary, which is usually 2 lines saying basically, thank you, examiner, for having the interview. Don't say it unless you don't mean it. I usually mean it. Thank you for the time. It was good. It was great. We had a good time. We had a lot of laughs. We talked about your vacation in Maine and so forth, your whatever, and creates a paper record. Everything needs to be created paper record. Patent prosecution is all done in paper, so anything you do not on paper needs to be reduced to paper anyway. And then here's the amended claims. You underline the new stuff, you cross out the old stuff, write currently amended, or you write original, withdrawn, canceled, so forth. It's just regular procedural stuff. Your remarks, you basically say what happened, let the examiner know so he doesn't go futzing through paper, make it easy for them to look at. It was rejected based on this was allowed, whatever, and here's arguments provided. Okay, now that's a good roadmap, and I know what you're doing. Now basically, I take that LOTO analysis and basically copy, paste, put it into paragraph format, to the point where I will even copy and paste the piece from the prior art, or like pictures, into my response. It's so helpful. And paste the paragraphs from the reference cited into the office action. Because now they don't have to go flipping through pages. Maybe they don't trust your citing properly, but you quote paragraph 39 of the prior art. There it is. You can read it. It's clear. And it's harder for them to argue. No, that did cite that, when it's right there on the paper saying not. It looks rather silly to argue it says something which it doesn't say. All right, and you state the law. This is here. I'm not going to read this, but it is in the slides if you need it. This is what you say in response to 102 rejection, what you say in response to the 103 rejection, the type of things we say in order to overcome prior art rejections, and what the law is. And here it is, the limitation, the office action, the text, and the argument. Claim 11, there's the office action. I copied and pasted it. And there's the text of what was cited in the actual office action. I actually had a picture of it right next to it. So you can see, here's the picture. This is what it is. You said figure 3. There it is. Here's the argument. Well, it appears to be solid. It's just sort of this RFID tag held at a central plane. It would have fell into the gravitational bottom. That's not what's shown. And that type of thing. So we don't really know, but in the absence of the patent office disproving it, the burden's on you to disprove that my claim is not new. It should be allowable. And sure enough, it was allowable. And conclusion, please allow the claims, please withdraw the rejections, and so forth. And this is what the issued patent looks like. So here are the claims that I talked about. It was actually claim 10. There's the cover of it. I have that right here as well. Not that you need to see it, but this is the cover of the issued patent, which lists the application serial number, the inventor, the abstract on the front page. That's so someone doing searching can hopefully read the abstract and figure out what's going on to see if it makes sense, just like an abstract on a scientific paper. Prior references cited. You have a duty to disclose all the references that you know of, and the patent office does their own references. And then based on those combinations of things, we come together and hopefully get a patent. And that concludes my presentation for today. Thank you. If you have any questions, please feel free to email me. I am fine giving information and talking to people. I like to teach. It's just being a patent attorney kind of, I don't know, it pays better. I work in my house. It's nice. Anyway, thank you. I can be reached at patentlawny.com or 212-316-0381.